because you are going to hurt or kill somebody, and then it's going to come back on me, and I'm not going to allow that.
25 CR 42773, 25 CR 43086, the State of Ohio versus Amanda Gallatin. Again, Ms. Gallatin is present with her counsel, Mr. Surrey, Ms. Nicholson, on behalf of the State of Ohio. We're here for sentencing. Ms. Nicholson, anything on behalf of the state?
Your Honor, we spoke about this at Chambers, and I did speak with Mr. Surrey prior to Ms. Gallatin entering the pleas in this case. She has done the mandatory minimum 60 days based on the felony OVI charge. I think the state did contemplate a higher level of care. She had already completed outpatient prior to the commission of the second offense, which was committed while the first offense was pending. She was released after doing the minimum time and is again an outpatient. She still seems to minimize the substance use issues and or mental health issues she has that led to the commission of these offenses, but we will rest on that.
All right, anything from probation?
Nothing further, Your Honor.
Mr. Surrey?
Judge, I had to review the PSI, and as the court's aware, we discussed this back in Chambers. I would just point out that Ms. Gallatin has been on both house arrest and TAD since her release in early December with no violations. She's working well with Officer Singendinger. She does have a letter of employment here. It's been verified in the PSI that she is employed full-time. I got a nice recommendation from her employer. And I also have a letter from Dr. Freudenthal, who is her psychologist, that she was treating with...
What was his name?
Dr. Freudenthal.
What a great name for a psychologist.
Yes,
right?
he was probably destined from birth. But I did get a letter from him verifying her treatment with him. She had stopped treating when she got incarcerated. She did speak with him and is eligible to resume with him as her psychologist. But as indicated by the state, she has been in treatment with, I guess it's Healthy Living Treatment LLC, but they go by Lumiere. She's been in their outpatient program. She was assessed there, and that's the determination that they made. I also have a letter from her good friend Rachel validating her character. Again, I think the court's aware of that situation. I know that Ms. Gallatin would like to address the court. I did speak with her briefly in the hallway after our chamber conference about the minimization, and she's going to address that directly. But I think, Judge, at this point, she has done the mandatory 60 days. Those were consecutive. I would ask the court to give her a period of probation with testing and treatment as recommended by probation in order to show this court that she can be successful. She does have 3 children. She is employed full-time. She is earning a respectable living. She's able to support herself and her family, and she is doing treatment. And she's already shown this court over the past roughly 6 weeks that she can be compliant and be abstinent from alcohol and substances. And I would just ask the court to allow her to continue with that path towards recovery.
Thank you, Mr. Surrey. Ms. Gallatin, anything you want to say?
Yes, Your Honor. I do want to address the minimization. When I had filled out the paperwork, I was in treatment when I was doing the PSI. So the fact that I was doing that and I realized that I have a huge problem that I need to address, and I'm taking the steps necessary to move forward, to better myself and my life. And I understand that the consequences that I have endured has affected myself, my family, my friends so greatly. And so I wanted to address that because this is an issue that I am being proactive about.
Okay.
Thank you.
Consider the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. Ms. Gallatin, I will say that it is alarming the number of OVIs that you have had. You're probably fortunate that you didn't get a second one in the second case. In this one, physical control was what you were charged with instead of the OVI, probably because they didn't see you behind the wheel of the car. I don't know. The minimization is one issue. 85% of people that get OVIs never have a second one. They learn their lesson from receiving the minimum mandatory sentence and then they move on. And looking back over your history, you've had This is like 6 now, is that right? 6 or 7?
The felony makes it the fourth. The physical would have been a fifth alcohol-related incident in 10 years.
Okay. But still, that's a lot. And
Yes.
when the courts continue to give you the mandatory minimum sentences, which is really what you're getting here, if you think about it, the 60 days in jail is the mandatory minimum. I'm going to tell you right now that I'm going to go along with what your attorney is suggesting. I do think that you have shown some progress, but I am telling you right now, I'm promising you right now, you're going to start drug testing on a very frequent and regular basis for alcohol. I think you have a serious alcohol problem.
Yes.
If you test positive for alcohol one time, you are going into custody. There's not going to be any, well, Judge, I have a job, or Judge, I have my kids to take care of. You
no
must,
excuses,
exactly, you must understand now, right now, that if that's your priority, then you make it your priority. But if you take cough medicine that causes you to test positive for alcohol, you are going into custody. Do we understand each other? Because anything that you put in your body, you are responsible for the results of the test. So if you say, well, I didn't drink any alcohol, but I did this cough medicine, that's probably what did it. Trust me, I've done this long enough where I've heard every excuse. I've had some of my veterans that have literally drank cough medicine to get high. So I will not accept any excuse for any positive alcohol test. Are we clear on this? Because you are going to hurt or kill somebody, and then it's going to come back on me, and I'm not going to allow that. So, having said that, I'm going to find that you're amenable to community control, so I'm going to place you into community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. You are ordered to refrain from the use of any drugs, alcohol, or marijuana. Are we clear on this?
Yes, Your Honor.
All right. You will ordered to continue to successful completion of the substance use disorder or alcohol disorder and mental health treatment. There's a mandatory $1,350 fine, which you are required to pay. The court also finds that you have the present and future ability to pay the cost of prosecution. If you don't pay those, I can't order you to do community service until you're paid in full, or you make arrangements to pay those off. You are under a 5-year operator's license suspension. You are not eligible for any privileges until after 3 years, so don't ask. Your probation officer is going to meet with you after court, and she's going to register you in what we call the CIP line. It's Cognitive Intervention Program, I think.
Gonna be honest, I'm not sure. I'm so used to calling
Anyway,
it CIP.
it's a drug testing line, and you're going to have to call it every day. You will be testing at a minimum, starting off with 3 times per week. You're going to drug test. This is accountability and verification that you're not drinking or using any drugs, for that matter. Okay? So we're going to start that off at 3 times a week. It looks like you have 63 days jail time credit, which means you've met the mandatory minimum. Ms. Nicholson, is there anything else before I go into the rest of the balance of this stuff?
The license suspension is effective date to the back of, or effective
Was she
back
under an
to the
ALS?
date. Yeah,
Okay.
because
And-
she was under the OVI suspension
Yeah.
the second time. I assume she was.
Terminate the ALS, and what was
It's
the
May
date?
18th of 2025 is the date of that.
Thank you. I did
Offense.
not write that down, but that's a good point. And then, anything else?
I don't believe so.
You're also subject to a discretionary period of post-release control, which means if the court sends you to prison on these felonies, upon your release, the adult parole authority may supervise you for up to 2 years. If you violate those rules of supervision, you can be returned to prison for up to 1/2 of the court's original sentence by the adult parole authority. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, all of that can be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. I know I come across as very harsh, and I understand that. It's just part of my charm. But I'm telling you, I'm very serious about this because I don't want to see you get hurt or you hurt someone else. You understand me? I mean,
Yes.
I know I come across as very harsh, but I believe that you can do this or I wouldn't be ordering this. Okay?
Thank you.
All right, good luck
Your
to you.
Honor, I'm sorry, 0 days of jail time credit on the second case,
Correct.
put it all on
Put
the
it-
OVI
Put it all,
case.
yeah, the 63, put it all on the first one, yeah.
And then, do you want court costs imposed in both cases?
Yes,
Okay, and no fine in the second case?
correct. Just
Okay.
a mandatory fine.
Okay, got it, thank you.
Judge, one other issue on offense, there's a vehicle forfeiture, but the vehicle was not registered or owned by her,
Yeah.
so there's no forfeiture in this.
There was no spec, Ms. Nicholson, there was no forfeiture spec on the vehicle, correct?
No.
Okay. All right, thank you, sir.
Very good.
All
Thank
right,
you,
good
Judge.
luck to you, ma'am.
Thank you very much.